Thank you everyone for joining us. Good afternoon. And on behalf of NAM, I want to thank you for joining us for today's presentation of Resolving Technology Disputes Through Alternative Dispute Resolution, presented by Paul Gupta, who serves as a neutral for both NAM as well as for NAM's newest division, Tapestry ADR. Paul Gupta has over 30 years of experience with arbitration, mediation, jury trials, and bench trials in technology and other commercial matters. He serves as an arbitrator and mediator and also represents parties in ADR and court proceedings. He is a member of the executive committee of the New York State Bar Association's Dispute Resolution section and is the co-chair of its technology committee. Mr. Gupta has handled a wide range of issues such as cybersecurity, data breach, privacy, e-commerce, IP, and employment. And Mr. Gupta is actively involved with the new technologies, including AI, robotics, AV, telecom, clean tech, aviation, technology, and medical devices. As a frequent lecturer on ADR and related issues, Mr. Gupta has presented at industry conferences, the RSA Cybersecurity Conference, and client sites. At the RSA conference, his co-speakers were two generals, including the former National Security Advisor to the President and the Supreme Allied Commander, Europe. According to Chambers USA, he is an expert in cybersecurity and renowned for his work in the technology arena. He has been selected for inclusion in Super Lawyers from 2006 through this year. So feel free, please, to submit any questions throughout the program through the Q&A feature at the bottom. And with that, I will turn it over to you, Paul.
Thank you very much, Sharon. I'm very glad to be working with you and very pleased to be on the rosters for NAM and NAM's Tapestry division. Today, I've been asked to talk about technology. And so I think the first thing I should address is, what is technology? And there are two ways of explaining that. One is, as I have here in my slide deck, which has been made available to you, there are various categories and subcategories. And as I go through my presentation, by the way, you don't necessarily need to be looking at my slide deck, but if you want to have it handy and make notes, I'd certainly encourage you to do that. I've listed a couple of different kinds of technology here. I think they can broadly be broken into computer matters, IP matters, employment matters, IoT matters, IoT meaning the Internet of Things, connected devices, including self-driving cars, clean tech, and health tech, and of course, AI. So let me pause and talk about AI because it's so much on everyone's lips, and mostly because people are concerned about it. And I think one thing that is really important to remember is that people have been concerned about new technology for as long as technology has existed. And by technology, and again, I want to be broad in my definition of technology, I'm going back to when the mills started making cloth 200 years ago, and people were terrified, and they were burning down the mills. And they said, we need to do this all by hand, otherwise civilization is just not going to be working anymore. And those people were called Luddites, which is a term you might have heard. Well, fast forward 200 years today, and I think in some ways, people are really overreacting to their fear of technology and specifically to their fear of AI. You probably see some of my books behind you, and I'll hold up a book that I pulled off my bookshelf by Ray Kurzweil, very famous visionary. And he says, his title is When Computers Exceed Human Intelligence. And that was written in 1999. And there's still a role for us lowly human beings. The robots and the AI still works for us, and we don't work for them. And I think with proper guardrails, we'll be able to keep that in place. We should also remember that technology over the years has created a lot more jobs than is displaced, and typically has created higher paying and better jobs. So why is this all relevant to ADR, to mediation and arbitration? It's because the growth of technology and the changes in the job market are going to spawn a lot more disputes, and they're going to spawn a lot more disputes that I believe, and I'm here to talk about today, are going to be better resolved in ADR than they possibly could be in the court system. I think that part of it is that judges are concerned about new technology, just like I said. the Luddites 200 years ago wanted to burn all the mills because they wanted cloth to be made by hand. You go into your typical courtroom, and judges are not only unfamiliar with technology, it's just the human reaction. If something is new, they're going to worry about it. And it's particularly difficult in the case of a judge because experience tells us that if you get in front of a judge with something that he or she doesn't understand, their knee-jerk reaction is, oh, you're trying to fool me. You're trying to pull the wool over my eyes, pun intended. And it just gets off to a bad start, whether you're the plaintiff or defendant. So there's some specific things that I think make it important to be seriously considering ADR for technology disputes. And I want to say one more thing about the broad definition of technology. Technology, in some sense, is what is the major factor for all businesses. Obviously, technology companies, but just as obviously, people who use technology. I was talking with a good friend of mine who was the former general counsel of a major household name financial institution. And he said, you know what, Paul, as you talk to me about technology, I'm realizing that what it used to be a financial company is really a technology company, because financial companies all basically market the same products and services. What makes them different is the way that they can deliver them through technology. And so many cases now, including some that I'm handling both as an arbitrator and as an advocate in front of arbitrations and judges, have to do with whether or not computer systems are properly working and meeting the contractual requirements. So I want to take these few minutes of introduction to make a point that technology touches everything, is increasingly going to be touching a lot of disputes, and is increasingly going to be creating a lot of disputes. I think the number one thing to think about when you are considering ADR is confidentiality. And let me pause and say, when I say considering ADR, it could be because there is a provision in a contract between two parties that are in privity and going into a dispute. And when I say in privity, I mean they have a contractual relationship, but they're going into a dispute, and there may be an arbitration clause. But increasingly, I'm seeing parties that do not have privity, in other words, are not in a contractual relationship, and their counsel can talk to each other and say, you know what, there's no requirement that we put this into mediation or arbitration, but wouldn't that be a smart thing to do? And you're seeing more and more cases, and an organization like NAM is so well equipped to deal with that, where parties will come to NAM and say, we would like to figure out a way to get this out of the court system and into mediation or arbitration. And then there's a whole process that you can work out where you can start just as if you had an arbitration clause in a contract. And that can be very valuable. And as these disputes are arising, I'm just seeing that more and more. Besides confidentiality, another reason driving technology in other cases to ADR is the cost of the court system and the extraordinary expense of litigation these days. Didn't always used to be that way, but now litigation is called the sport of kings because it's so expensive. And I'll have more to say in a minute about confidentiality and costs. Another reason that ADR can be very attractive is because of the technical and specialized nature of technology calls for someone with specific expertise. If you choose your mediators or arbitrators carefully, and NAM is very well set up to help you do that, you're never going to get a situation where you walk in front of a fact finder and they say, we have no idea what you're talking about. And in fact, you pick up, although they'll never say it, we're kind of scared by what you're talking about, because nobody likes to seem like they don't have the knowledge. Another important issue for considering ADR for technology is that technology moves fast. You can start a court proceeding, and by the time you're partway through discovery, the technology can be outdated, it can be leapfrogged, whereas the parties can agree with the mediator or arbitrator to move the matter much faster. than you possibly could in the court system. Another reason that I've seen ADR to be a really good tool for resolving disputes is that companies, particularly when they have different divisions or different lines of business, can have a dispute about one division or one line of business, but continue to work with each other on other aspects and work productively. And that can make a big difference. What happens, and I've seen it, I do both arbitrations and litigations, is with arbitrations, there's a certain level of civility which people can maintain, particularly in the hands of a good neutral. Whereas in litigation, there's just a sense of taking the gloves off. A lot of mud gets slung. Judges are not really equipped to control tempers. And so what might be a problem between two divisions and companies all of a sudden escalates to the companies can't get along at any level. And that can be a really bad result. Whereas with ADR, you can at least have parts of companies being collaborative and cooperative with each other. Another reason why ADR can be much the better choice than courts is because of because everything in the world, particularly technology, is going to have global aspects. And a lot of my cases, again, both sitting as a arbitrator and also when I'm an advocate in front of a neutral or in front of a judge, touches on different countries, oftentimes with different laws. And one just has to be sensitive to that. A US court will be very strong on US laws, but may not be comfortable understanding how issues work in different parts of the world. And sometimes this calls for a situation. I had this case a while ago where some issues should go to ADR and some issues should stay in the court. And that takes some pretty careful reasoning and thinking. In the case I was referring to, whether the matter was in arbitration or whether it was in court made a big difference because the law that would be applicable would be very different. If it was in a US court, then US law would apply. And if it was an arbitration, then a different law would apply. One was favorable to the plaintiff, one was favorable to the defendant. And those kinds of issues really had to be thought through and can also drive the decision on whether or you want an arbitration to go forward or you want a court to handle it. You really should consider the choice of law difference and the impact on your situation. Let me do a little bit of a deeper dive into confidentiality. In litigation, everything is publicly filed and the milestones are public. It used to be in the old days that you could file a complaint and keep it under wraps and use that when you wanted to, pop it out when you wanted to. So you could go into a negotiation, file a complaint in court, nobody would know about it, and then you could pop it out if the negotiation went badly. If it went fine, you could just dismiss the case, nobody would know about it. Well, that was yesterday. The way the world works today is if you file a case of any magnitude, it gets picked up in the press, certainly in the trade press. There's something called, for example, Law 360, which reports on new cases. And it's very hard to keep cases under wraps. The other thing that's hard in terms of confidentiality in the court system is that judges don't like to seal cases. They don't like to seal pleadings or declarations or affidavits. Their notion is that the courts are a public forum and everything should be public. That can be really difficult if you're in a technology dispute and you don't want the keys to the kingdom to be out there for everybody to see. A good example of that in a case that you may not think of as a technology case, but really is where you have a company that is not getting its computer services as it thought it should. Now, the company doesn't want to disclose the fact that it's struggling to meet customer demands, and the computer company doesn't want to disclose the fact that maybe its products aren't working so well. But if you go into court on that kind of dispute, typically everything becomes public, and people who are following the company or are following the computer business are going to pick up on it. But if it's in mediation or arbitration, typically you can keep that under wraps, which is a good place to be. For arbitration, there is no public record and everything can be kept private. I should hasten to add, though, that you have to make sure that on top of the inherent confidentiality that you get in ADR, that you really should have a robust confidentiality agreement, protecting the confidentiality of the proceeding, the confidentiality of the discovery, materials. I'd like to have a separate provision about so-called AEO, attorney's eyes only. I want to say testimony should be kept confidential and an award should be kept confidential. One should also think about that when one looks at the combined effect of the inherent confidentiality of proceedings such as NAM proceedings, supported by a confidentiality agreement, that sometimes proceedings or awards have to be made public. I've had some matters where public authorities are involved or governments are involved. You have to check requirements to see what has to be disclosed in that event. And if you're dealing with a public company, there may be disclosures that about awards or settlements that you have to think about. And again, as I've already indicated, and I'm going to make more comments about in the future, it helps to have the experience to look ahead, know what the twists and turns are of the, as you traverse the road, and make sure you've thought about everything at the beginning when you still have a chance to control things. Another important confidentiality tool is in-camera review, where if you have documents that the other side wants, then you can submit to the arbitrator the documents and say, please review them in camera, which means privately. And then you make the decision, Mr. or Ms. Arbitrator, as to whether or not they should be shown to the other side. Now, there is this in-camera review that's possible in the court system, but with judges and magistrate judges so overwhelmed with cases, it can be really hard to get attention. And the in-camera review procedure, which is a very, very useful tool that more people should know about. As I said, I'm doing one right now, sitting as an arbitrator in a case, is something that should really be considered as one more tool in the toolkit to keep your matters confidential. I want to move on to tribunal experience. And I've touched on this a little bit, but again, I want to do a deeper dive and illustrate some points in terms of matters that I've handled, both sitting as a neutral and as an advocate in front of neutrals and judges. I've already mentioned that judges are oftentimes not experienced with technology matters. And I wanted to explain that the other thing about judges is that they will come with personal backgrounds. And when you get to court, you file your case, you enter your case on the wheel, a judge comes up, you have no control over it. I've had cases in front of two excellent judges very recently. One came out of the ACLU, the other puts on his judicial website that he is a member of various conservative organizations. They're both great judges. All the organizations are fine organizations. But wouldn't you want to know that before getting into a dispute? With a judge, you have no way of knowing that in advance. With a mediator or arbitrator, well, NAM is going to do its job and flush that out as part of the disclosure process, so you know that information before you get in front of a fact finder. Now, I mentioned the political affiliations just as something to maybe get your attention, but it can be a lot more subtle. And yes, judges have to disclose who they work for, but again, a lot of times when you get in front of a judge, it's too late to say, oh, if I had known that, it would make a difference. But of course, once you get the work history and you get a sense of who a neutral has worked for, what kind of cases they've handled. That can be really, really helpful. In my own particular case, my practice is a little unusual because I do a lot of work on both the plaintiff side and the defendant side. But you really want to know what you're getting in a fact finder, and the visibility is next to nothing when you get in front of a judge, because the wheel comes up and you get who you get. On the other hand, with the way that NAM screens its neutrals and makes the information available to parties, you know exactly who you're going to get. And if political affiliation makes a difference, if industry affiliation makes a difference, if it makes a difference to you whether he or she, the proposed neutral, has done mostly plaintiff's work or defendant's work, well, you get to find that out before you pick somebody. And that could make a big difference in terms of the outcome. It can also make a huge difference in terms of how you feel about the process and how your client feels about the process. So sometimes clients, particularly when they have big caseloads, will say, look, winning is really, really important to me, but it's also important to me that I can keep on budget and I know what I can expect. And also, it's important to me that I feel like it's a fair process. And I've had so many in-house lawyers say to me, look, I can live, and my boss, you know, who's maybe a vice president or senior vice president or executive vice president or the CEO, or in really big cases, the board, they need to know it's a fair process. If I can go to them and say, look, we picked a neutral, we knew what we were getting into, it didn't work out the way it did, but I can't tell you that it was an unfair process. I can't tell you that there was a bias that was not disclosed. Nobody's going to feel good about losing, but at least it's a way that an in-house counsel can explain the process in a way that business people can understand it. So this whole notion about tribunal experience, but also knowing that experience before you get into a fact finder can pay huge dividends in terms of not only the outcome, but also the way that your business client or you yourself feel about the result. I have to tell a couple of stories about that. I'm in front of a judge recently, and I was trying to present a technology issue to the judge, and the judge literally said on the record, on the record, he said, Mr. Gupta, I'm just a country lawyer. And what that told me was he was really struggling to understand what I was telling him. And he was also maybe a little skeptical about, well, hey, is he telling me something in a way that I should not understand because there's something in there that doesn't want me to understand? Well, no, this judge was a very good judge, and I was glad he said that to me. I always like it when a fact finder is honest with me. And I said, well, Your Honor, I understand the issue here, and let me back up and explain this a little bit more in depth. And he started smiling after, and he gave me plenty of time to talk, which is unusual in a court, by the way. Usually it's, oh, my next case is coming up. I got 10 more minutes for you, but this judge was great. He took the time. I was able to let him give me the time I needed. And at the end, he said something else that was memorable to me. He said, well, Mr. Gupta, you've convinced me that I want to do it right rather than do it right now. But those judges who will take the time and pause and tell you if they have an issue, I'll tell you, those judges are few and far between. Whereas with an arbitrator or a mediator, you're guaranteed that he or she will have some background knowledge and also is the kind of person who will say, I'll take the time I need. That's my job. I think the last thing I want to say about tribunal experience is, particularly with courts being so backed up after COVID, a lot of times I'll get in front of a judge, and even a good judge, even a judge I respect, and he or she will say, well, I'm so sorry, counsel, I haven't had a chance to read your briefs, but I've allocated an hour for your argument, and I guess you got to use part of that hour telling me what was in your briefs. And my team and I are kind of looking at each other saying, this brief that we filed, we thought was just a really good exposition of our position. And also in technology cases or more complicated cases, it's a lot easier to explain what the issues are in writing, because you can drop in diagrams, you can drop in illustratives, demonstratives, whereas if you have to explain it in words in front of a judge, it can be harder. I've actually learned to anticipate when I go into court that a judge may not have read my briefs, and so I'll go in with demonstratives and I'll say, may I pass up diagram X, and that'll make the argument go a lot better. But frankly, I shouldn't have to do that, and I wouldn't have to do that in the case of a mediator or an arbitrator. If a mediator or an arbitrator ever said, as you walked into the room with them, well, I'm sorry, I haven't had a chance to read your briefs, both sides would look at each other and say, this person needs to be fired on the spot. And that would be something both sides would agree on. But again, with the kind of neutrals that are on the NAM roster, I can guarantee you that would never happen, because NAM carefully screens them. That gives me a chance to talk about something else that's very important in terms of tribunal experience, which is you really want to make sure that you're working with NAM if you want to get into a mediation or arbitration, rather than to create your own rules. As I said, there's an increasing trend, even when parties are not contractually bound to go mediation or arbitration, to say, you know what, let's keep this out of the court system, and let's come up with our own rules, and we'll administer ourselves. And they'll say, well, we've worked with Joe or Jane, and they're good people, and we'll just grab one of them and they can be our mediator or arbitrator. That sounds good, but it never works. And at least not in my experience. I've never done it, but I've heard war stories about people trying to do it. And it doesn't work, first of all, because the rules for a good mediation and arbitration are complex, and NAM has those rules. And the other problem is that this neutral that you kind of pick because everybody knows them may not be so neutral after all, and that leads to a lot of bad feelings. And there have been some stories about the neutral being friends with the lawyers on both sides, and one lawyer will walk by and see the neutral having lunch with the lawyer on the other side, and it may be perfectly innocent. But nobody thought to say to the neutral, by the way, while this proceeding is going on, which is not administered by NAM, they're just trying to make up their own rules, you shouldn't socialize with either of us. And it's that kind of thing that nobody thinks about in advance, except for NAM, and they'll do a great job in terms of finding a neutral who really is neutral, and who will stay neutral. And the part about staying neutral is something that is oftentimes overlooked, but just critically important. I want to turn and talk a little bit more about the process. One of the important issues here is sometimes, particularly in a technology case, you need to have an emergency hearing or a fast track hearing. When you're talking about product development, well, that's obvious, because you've got a product and it could be obsolete in 6 months, and you need to have something resolved right away. When you have an employee departure, well, that's obvious, because if the employee is setting up a new company, you can't wait 2 years to find out whether or not that employee should be allowed to continue with his or her business or should be shut down, because in 2 years they may have stolen or legitimately taken, depending on your point of view, that business. But the need for emergency or fast track is also true in more conventional business relationships. For example, I mentioned the issue of a computer company processing for a hardware store. I've got one of those cases right now. Could be a bank, could be any kind of business. But if the processing is not going the way it should, then there's a real problem, because the computer company may not be paid. And the business, be it a hardware company or a bank or any kind of other business, may not be able to do its business, may not be able to serve its customers and clients. And so if you go into court, then there are processes for trying to get a judge's attention right away. But it's getting harder and harder. What I've found personally is that if I'm representing a client that needs emergency relief, and for whatever reason, I'm required to go into the court system. Before COVID, it was possible if one knew the clerks and had a good relationship with the clerks to get reasonably speedy treatment. After COVID, it's just about impossible. Some states have a million case backlogs of cases waiting for trial, waiting for judicial attention. And a million case backlog, that's not a figure of speech, that's a real number. And on the other hand, if you get a mediator or an arbitrator, the NAM system is very well designed to move very quickly. You can get somebody on board within days if you need to. That person will, by definition, have the right kind of background for your case. And you can empower that person to issue emergency orders. There used to be kind of a myth that only a judge could issue emergency orders. That's not true. If you have a contract, either because the parties are in privity or because the parties agree to an arbitration contract, then you can empower the arbitrator with exactly the same kind of powers that he or she would have if he or she were a judge. And that's a very powerful tool to get emergency relief rather than wait the 2+ years that it would take to get the attention of a judge. I think it's worth emphasizing the random selection of the judges. Again, I've talked about this a little bit, but the fact is you never know who you're going to get. The reason I wanted to touch on a little bit more is that particularly after the extra burdens that COVID has caused, a lot of times you're getting senior judges, retired judges who are coming off the bench, and they're basically paid by the day. And you just may feel that, with all due respect to senior judges who have had distinguished careers, you're not necessarily getting someone who's as plugged into the system as a sitting judge might be. Senior judges are going to have other things on their plates, and they get pulled in as need may be. But then the senior judges may also not be available. I've got some cases right now where we've gone through 4 judges, 2 of whom are senior judges, and you put a little piece of the case in front of them, and then the senior judge steps out, and then another judge comes in. And these cases that I'm referring to have complex facts. They go back a while. There's a fair amount of history. The legal issues are complex. There are multiple legal issues across various causes of action. And we're doing fine. But it's really hard. It's extraordinarily expensive to gear up and present to a new judge and get him or her up to speed. In this case, I'm in my 4th judge, and I got to get this 4th judge up to speed with everything that the prior 3 judges knew. That would never happen in a NAM proceeding, because you'll get a neutral, and that neutral will stick with the case. So that's a point that I wanted to emphasize when it comes to process. I've touched a little bit on judges rationing time, but I think I need to say a little bit more about that, because the fact of the matter is that judges have very full calendars. They may have, particularly after COVID, a caseload of literally up to 1,000 cases. Again, I want to use this as another example to talk about pre-COVID and post-COVID issues. I think the need for NAM has just grown exponentially because of COVID, because of the damage it did to the court system, and the fact that you have all of these backlogs, and courts have to make do with what they can. They have to allocate their cases. In a lot of courts, criminal cases come first, and there's no lack of criminal cases. So if you've got a civil case, even though it may be the most important thing in the world to you, it just won't get the attention. It can be very frustrating. It can be very frustrating to the lawyer. It can be very frustrating to the client who just doesn't understand why this very important dispute is just not getting any attention. And for those of you who are inside counsel, I know you don't want to be in the position where you're explaining to your business client why the case is not moving and getting the attention it deserves. You're typically not going to have those conversations in a NAM administered proceeding because they will give you somebody who will have the time, who promises to have the time, who will have the continuity, and who will pay attention. Another problem with litigation in terms of the process is that a lot of times you go into court and the technology platforms are outdated. I recently had a jury trial with all kinds of problems, some of which I'll talk about in the rest of my comments here today. It came out fine, I won it, but it was a lot more expensive than it had to be because of the fact that so much in the court was antiquated. For example, when I was presenting exhibits to a witness, I had to use something called Elmo, and those of you who are trial lawyers are probably nodding because it is just it's something you might have seen in grade school where you put a piece of paper on a platform and you have a light and then you have an arm over the light that projects the image. Very antiquated machinery that breaks down all the time. You would never have that in a NAM administered mediation or arbitration because NAM's platform is state of the art and it would all be up on computer screens. You're now seeing some courtrooms where everything can be on computer screens, and even the juries will have computer screens in front of them. And you probably have seen that on TV and in the movies, but I can tell you as someone in the trenches, yes, you're lucky when you find that, but even in major cities, that's oftentimes not the rule. Oftentimes courts are in terrible shape physically and just don't have the kind of technological equipment that you might expect. But you can always get that kind of technology in a NAM administered proceeding. In arbitration, you have, as I said, the advanced technology platforms available. And I was chatting with Sharon earlier, and it may be that we ought to do a whole program on what those kinds of platforms are and the kind of technology that NAM can offer its clients. In the interest of time, let me move on to cost and time as we're comparing the benefits of mediation and arbitration on the one hand, the litigation on the other hand. A couple of things are particularly important. One is discovery. The largest cost now in today's court litigations, especially in federal court cases, is basically unbridled discovery. The federal rule is very broad, saying you can take discovery of anything that may lead to admissible evidence. It doesn't have to be admissible evidence, it just may lead to admissible evidence, and courts have construed that broadly. And a lot of times, one party will use that to bludgeon the other party, and particularly when the parties have unequal resources. That's not always a blessing for the party that has the greater resources, because oftentimes you can find counsel who will spend an inordinate amount of money on that case, much to the chagrin of the inside counsel that's involved with the case. We have to keep in mind, of course, and those of you in the trenches know this, that there are multiple levels to whether a case is well run or not. Most obviously, do you win the case? But do you win the case at what price? And in-house counsel have told me time and time again that what they appreciate is not only a pat path to victory, but a predictable path in terms of what the cost is going to be and when the cost is going to be incurred. In litigation, it's very hard to predict the cost because you just don't know whether you're going to have lawyers on either side run up the costs. And even if one side may get a tactical advantage in running up the cost by engaging in aggressive discovery, that may be a Pyrrhic victory, because then the inside counsel may step back, get the bill, and say, "Whoa, you didn't tell me you were going to do this." And the trial counsel, not me, but the trial counsel would say, "Well, gee, I thought you wanted to win." And the inside counsel will say, "Yeah, but there's a cost involved. I got 100 cases, and I can't be running all my cases like this." So some of you may have been privy to those kinds of conversations or heard about them. So the fact that there's unbridled discovery is not necessarily a benefit for either side. The other problem with litigation is that it's very hard to predict the costs. I've had any number of inside counsels say to me, "Okay, here's your budget." And I'm saying, "Look, it's expensive. It's a big case. It's expensive. I can't do much about it. I can trim a little bit here and I can trim a little bit there. Let's work on it together." I'm a big believer in engaging inside counsel from day one of the budgetary process. And the inside counsel will say, "Look, this is important. We need to win the case, or at least do a really good job. I'm going to approve your budget, but I'll tell you, Paul, what I really need you to do is to make this predictable, so I know what to budget Q to Q, because that's how my business clients budget." And I'll have to say to them, "Look, in a litigation, I've got a pretty good sense of how it's going to go. But if it's a patent case, for example, there may be a stay. If it's some other kind of case, there may be situations where the judge is doing a criminal case and it's just not available for 2 months." And I said, "I can control what I control, but it's very hard to give you the kind of quarter to quarter predictions that you would like." If you compare that with mediation or arbitration, it's very different. When I sit as an arbitrator, the first thing I do, and this is true for all arbitrators, is I get the parties together and we agree on a schedule. And we say, "Okay, here's the schedule, and you're going to have to stick to it except for good cause shown." That's very different from setting a schedule in a court proceeding where you've got rough milestones, and they always get changed depending on the judge's schedule and whatever trials the judge may have. And so while there may be attempts to set schedules in both arbitrations and court proceedings, I can tell you, based on my own experience, that the schedules that are set in arbitrations are far more likely to be held to. And that means that the inside counsel and the client can have far more predictability on quarter to quarter spend. And that can be a real difference in terms of whether or not a litigation is perceived and is in fact flexible. Another big difference in terms of cost and time is that in arbitration, there's a lot more leeway than an arbitrator has to set procedures and set deadlines. Courts, particularly trial courts, are oftentimes constrained by the federal or state rules. The federal or state rules may be pretty good rules for most cases, but like any rules, they're not necessarily going to be the right rules for all cases. And it may be difficult for a judge to vary them, or a judge just simply may not have the time to say, "Okay, well, I'm going to tweak, rule 41 or 37, whatever, to fit to this case." That takes some real thought, whereas an arbitrator, well, that's what he or she is paid to do, is put some time in up front to make the case go smoother, which will have consequences that will result in savings of time and expenses later on. And that ability to basically customize a case and customize the way it's handled is much greater in an arbitrator's hands than in a judge's hands. Another important issue for cost and time is the fact, and this is a dramatic difference between arbitration and court proceedings is that in arbitration, expenses and fees can be shifted. We all know that in the U.S. system, typically what happens unless there's sanctions or something unusual is each side pays for its own costs and its own legal fees. Arbitration is more like the English system where costs and fees are allocated. And that can be a very important issue when you're running the case. It's obviously an issue at the end of the case, but what I'm finding is that, particularly when I'm sitting as an arbitrator, is the fact that if either side acts in a way that it shouldn't, it can get punished by having costs and fees assessed against its client. And so, for example, I've got a case right now. Obviously, I won't talk about the details of the case because it is confidential. But the counsel were kind of going after each other, and a lot of the briefing that I got as an arbitrator were just filled with insults. And I said, this has to stop. It has to stop now. And a lot of judges will say that, but the reason, as an arbitrator, I could say it and had some teeth was I said, if this continues, then I'm going to keep this in mind when I assess costs and fees at the end. As soon as I said those words, everybody was in perfectly good behavior. Everyone was civil. And it was so much different than when a judge with all his or her powers says that, because a U.S. judge just doesn't have the power, except in extraordinary circumstances, to have the power that an arbitrator has to allocate fees and costs, which can be done for bad behavior. So that's a great tool that an arbitrator has in his or her toolbox, which not only affects the end of the case, but can, if used appropriately, as I just mentioned, can make the proceedings much more civil, which means that they're going to be a lot less expensive and go a lot faster. I also want to talk about finality of proceedings, because that can be another huge difference in terms of whether you want to pick the court system or arbitration. In litigation, the main issue that will drag out the case, apart from the ones I've already talked about, which will mean the typical litigation will last far longer than the typical arbitration, is the appeals. The appeals can be endless and they take a long time. They can add 2 to 5 years to the life of a case. And one doesn't necessarily get any benefit. The result oftentimes is the same as the trial, but again, the parties are left in limbo, and that's oftentimes bad for both parties. I want to emphasize that just because one party has greater resources and can do things in litigation they can't do in arbitration, doesn't necessarily make for a better result for the party. They may need some finality. They also want to control costs, which can be harder to do if you're locked in a system where you feel like you have to take an appeal or you're on the other side of an appeal. In arbitration, there is a process for an appeal, and I want to talk a little bit about a very recent case, not one that I was involved with, thankfully. You'll know why I say thankfully in a minute, where the arbitration did go up to an appellate court. But I want to talk about it as I close out my comments, partly because it's such a rare bird, but also because in the course of the opinions, there were a lot of discussions about issues that cut across some of the things I'm talking about. Will be a good way to summarize them. This was a case where the court recognized when it was asked to vacate an arbitration ruling, and vacating arbitration rulings are few and far between. And the court said, well, I can only do it if there's, quote, corruption, fraud, and undue means, close quote. And those are very tough tests. That means that appeals typically from arbitrations are much more difficult to take than from trials in the court system. Now, in this case, which was maybe 1 in a million, the court did find that the arbitration decision had to be vacated. And the reason for that was an extraordinary, maybe unique set of facts where a witness in the arbitration was testifying, but was getting cues via his cell phone from someone prompting his answers. So just picture this: you've got, and again, this is the kind of thing that is happening much more typically post-COVID than pre-COVID. But you've got a proceeding and an arbitration. People are testifying. Nobody's in the same room, right? The witness is in one room. His or her lawyer may be in another room. Counsel and parties for the other side are yet someplace else. The arbitrator or the three panels, the three-person panel is someplace else. And nobody's really kind of watching what people are doing. So the witness in this case was talking into a screen and somehow managing on the sly to look at a cell phone. And the cell phone was sending him texts saying, here's how you answer the questions. And it was perfectly clear when they found out the time sequence of the answers and the text coming in, exactly what was going on. And that case went up to an appeal court. The appeal court said, not surprisingly, yes, this arbitration decision needs to be vacated. So I talk about this case because it shows how incredibly rare and how incredibly difficult the facts have to be to justify an arbitrator's award being vacated, and how almost impossible it is for that to get beyond a trial court. Now, a trial court does have to confirm an arbitration award, but generally, except in extraordinary cases like this, that's a rubber stamp process. That takes me, because I think I've got a couple of minutes left, and I see I'm not getting any questions. By the way, if you do have questions that you think of afterwards, please send them on to NAM and they'll forward them to me, and I'll be happy to give you personal responses. But in my last couple of minutes, unless I get questions, I want to use this case I talked about to show that the appeal process is really not something that is going to be a factor in an arbitration. That allows me to segue to something else I want to talk about, which is maintaining the integrity of witness testimony. And so that's a blatant example of engaging in sanctionable conduct, which nobody should engage in. But there are a few more subtle issues there that I should mention, because I see sometimes that they're not observed unless people are reminded to observe them. The most important is that non-party witnesses should be sequestered until they complete their testimony. That's the rule in most courts, but sometimes is not observed in arbitrations. But in my view, it's just as important in arbitrations as it is in courts. You don't want witnesses to be hearing other people's testimony, because that could contaminate their own testimony. And there are various ways in which a good arbitrator can make sure that witnesses are insulated where they need to be. An exception is expert witnesses typically can attend the whole entire proceeding, and that makes sense. But it's details like that that an arbitrator needs to know to make proceedings in arbitration benefit from the kind of rules that have been built into court proceedings that may not be obvious unless the arbitrator knows about them. Let me then move on to my very last section. Again, let me just check for questions, which is what should be in arbitration provisions. I've talked a lot about the fact, and you all probably have the experience of knowing that most arbitrations get started because there's an arbitration clause in contracts between parties who have privity. I've also mentioned that increasingly parties in a dispute are saying, look, we're not required to get into arbitration, but that would be a smart thing to do. Let's go to NAM and they'll help us devise a structure and find an arbitrator so we can make this work. But for the majority of cases where there is an arbitration provision, there's some important things to include. And I want to emphasize this because time and time again, I see both as an arbitrator and as an advocate that the arbitration clause typically is part of the so-called boilerplate at the end of a contract. Typically, it's the last thing that's done. It's done late at night. With all due respect to junior associates, it's typically done by junior associates without any partner overview, and it typically doesn't have the basics. So let me tell you what the basics are, and these may be some slides that you want to keep and refer to if you think they would be helpful. First of all, the rules to be used, that's easy. You want to use the NAM rules, which are very good and comprehensive. You want to talk about the location of the evidentiary hearing. That can be very important because you may well have parties that are in different parts of a state, different states, even different countries. You need to give more thought to this than may be obvious, because when you choose the location, that'll be referred to as the seat. Seat is a word of art for arbitration, which means some of the laws of the location will be incorporated into the arbitration. Those will be the procedural rules. You also need to specify what the substantive rules are, and that should be part of your arbitration clause. And the substantive rules may be in a different jurisdiction than the procedural rules. Again, the procedural rules will typically be the rules of the location, the courts there, or the tribunals there, whereas the substantive rules should be spelled out. And in the case I mentioned, a lot of times it really will make a difference which seat you pick, set of rules you pick for the substance, because the rules can be surprisingly different in different jurisdictions. This is something that you can't do past midnight when you're putting your ADR clause together. You got to think that through in advance and think about what are the possible seats and what are the possible jurisdictional requirements, and think about which are going to benefit you or your client. You also want to think about whether the case will be heard by a single arbitrator or a panel of 3 arbitrators. That can make a difference, and that could be a whole seminar about which is better, a single arbitrator or 3 arbitrators. I think it's smart to, in your arbitration clause, specifically say that the arbitrator will have all the powers that a judge would have. Unless that's specified, it can lead to a lot of confusion, particularly in the case of emergency relief. Because as I said quickly before, if you need emergency relief or fast track relief, and it's not specified that an arbitrator can give you what a judge can give you, there can be a lot of confusion. And that's pretty standard language to put in, and more and more arbitration clauses are including that. I think when you draft an arbitration clause, it's smart to put in some rules about how much discovery can be allowed. You can let your NAM appointed arbitrator decide that, and that's fine too. But the parties can agree in advance as well. They have the option to do that. Another important detail that people sometimes don't think about in terms of the arbitration clause is the type of award you want. The process at the end of the day is called an award that the arbitrator renders, and it can be a standard award, which simply is an injunction type ruling and or a dollars and cents ruling, or it can be a so-called reasoned award, which is more like a good judge would do, explaining the law, explaining the facts, explaining how the arbitrator applies the facts of the law. But you don't necessarily get that in an arbitration unless you ask for it either in the arbitration clause or in the initial conference. There are a number of things that I talked about that can be resolved in the initial conference with the arbitrator. And again, that could be a whole nother seminar, so I won't get into that, except to say that if you're getting into an arbitration, there are multiple opportunities to set the rules ahead of time before the dispute really gets intense. I mean, the best time to do it is when people are entering into a contract because they want to do business with each other, and there are high expectations that it's all going to be friendly. And that's a great time to be dealing with some of the things I just talked about, because typically there's not going to be a lot of pushback because nobody thinks there's going to be a dispute. But if there is a dispute, all is not lost, because you have the opportunity when counsel have their first meeting to talk about how the case is going to progress, and or when they get in front of an arbitrator to set the rules of the road. Now, there may be a dispute. The parties are obviously not happy with each other, but I can tell you from experience that things are only going to get worse. And so if you have the opportunity to set ground rules early on, it's always going to be easier than if you try to set them when the situation arises when you need them. I think I've hit my 1 hour mark, and I think that unless Sharon wants me to keep going, or unless there's some questions that for whatever reason I'm not seeing, I probably should sign off, but I want to thank you very much. You've been a terrific audience. I understand there have been about 150 of you who signed up, and it's been a real pleasure having a chance to talk with you.
I just want to thank you, Paul, for presenting today, and for each of you for attending today's program. I hope you'll join us for future programs. In case you do have any questions after the program, please feel free to submit them for Mr. Gupta to answer at cle@namadr.com. That email address, as well as Mr. Gupta's email address, is in the handouts. And once again, I thank you very much for joining us. Thank you.